This is an application and appeal in the matter of Dell and another and 89 Holland Park, into brackets, Management Limited.
Yes.
My lords, my lady, I, together with Mr. Blakeney, appear on behalf of the appellants. My learned friends, Mr. Loveday and Miss Green, appear on behalf of the respondents. My lord, there are three matters listed this morning. One is the substantive appeal, but then there's two applications in connection with that appeal. One is brought by the respondents and one is brought by the appellants. The application that is brought by the respondents is for an order under section 20C of the Landlord and Tenant Act 1985, which is effectively for an order preventing my clients from recovering through the service charge their costs, or through the respondent service charge, their costs of these proceedings. It's agreed that the determination of that application should be deferred until the substantive decision on the appeal is delivered. And it's proposed that submissions on the application be made in writing at such time as the court directs as convenient.
That makes complete sense, thank you.
So the second application, my lord, is my client's application, and that's for permission to amend its grounds of appeal, or to add an additional reason to the ground that the Upper Tribunal is wrong in its decision that the subject costs, the disputed costs, are not recoverable through the service charge. And I'm in the court's hands as to when it is most convenient for myself, and then in Mr. Loveday reply to address the court. I can do it now if that's convenient for the court.
Well, you do it when makes most sense. You don't have to do it now if it's more convenient to deal with it when you reach an appropriate point in your submissions. That's fine.
I'm grateful. A reading of the clause is unavoidable when dealing with the other grounds. So we'll be looking at the ground. Necessarily the arguments, because they concern the interpretation of a service charge provision, materially overlap. So they are broadly the same arguments that apply to the quotes additional ground. So perhaps if I may then just park that for the moment.
Mm-hmm.
So perhaps the convenient place to start is with the contractual documentation.
Yes.
So as the court will be aware, the appeal concerns the recoverability of costs incurred in connection with litigation and a planning application made by Sophie Hicks to develop a neighbouring plot of my client's land. I will look at the documentation, but just for the court's note and convenience, a detailed exposition of each of the relevant deeds which contain the restrictive covenants is set out in the decision of Robert Miles, which is the first claim. So that's the first claim challenging the reasonableness of a refusal of consent, and that's in the authorities bundle at tab 9. It's from paragraph 15. There's a full recitation of all the clauses and the history. But looking, if we may, so perhaps if I can take it fairly summarily for present purposes as to the documentation, I would start with the 1965 deed. So I'm in the supplemental bundle in the first tab. That's the first relevant contractual document in time.
Yeah.
And it was by this transfer, this is a deed of transfer, it's by this document that the neighbouring plot, which was formerly part of the garden, was transferred out of ownership of the owner of number 89. And what this deed contains is both positive and negative covenants. So they can be, the clauses and the covenants are set out in clause 3, which begins at page 2 of the deed. The first one is not of relevance. It's to do with restriction on sale. The first relevant clause is page 4, which is subparagraph 2. This is a positive covenant. Now, this just to put in context, this covenant won't and its successor isn't relevant to the dispute with Sophie Hicks, but it is relevant to a case that went to the High Court, which is said to be part of the relevant background, which is why I mention it, or I draw attention to it. So there is a positive covenant for the purchaser to erect a wall. It's to erect a building, I beg your pardon. And critically, in the second part of the clause, is that not to procure any modification of the approved plans and make no application to the planning authority unless such proposed modification shall first have been submitted to and approved by the vendor, but so that the vendor shall not unreasonably refuse such approval. So there's a restrictive covenant not to modify plans for the building, not to apply to the planning authority for any modification, for permission to modify any plans without prior approval. And the approval is not to be unreasonably withheld. And subparagraph 3, the definitive plans of the said building, together with all working drawings and specifications, shall be submitted to and approved by the vendor before any work is commenced, but so the vendor shall not unreasonably withhold such approval. So the process is there, you get planning permission, there are some improved plans, you have planning permission. If you want to modify the planning permission, you need consent. The consent is not to be unreasonably withheld. Once you've obtained your planning permission, before you embark upon the works, you have to get approval of the definitive plans. To correct myself, the positive covenant regarding the brick wall is at subparagraph 4. The purchaser shall forthwith erect on the said land a brick wall separating the said land from the remainder of the garden of number 89 Holland Park. One can see at page 3, where there's a plan where there is annotated the intended location of the boundary wall. The obligation to build wasn't carried out in time, and there was a modification to the deed in 1968, which is at tab 2, beginning at page 7. One can see at clause 1, the adjoining owner hereby covenants with the building owner hereby covenants with the adjoining owner. So the building owner is the owner now of the plot, and the adjoining owner is the owner of number 89. That she will complete the development of the building site in the manner aforesaid no later than the expiry of 18 months from the date. Then over the page at clause 2, page 8, in lieu of the drawings referred to in the said transfer, so that's the earlier transfer from 1965. The adjoining owner hereby approves the general layout drawing 16013 dated April 1968. Then subparagraph B, the building owner shall make no application to the appropriate planning authority nor apply for any other necessary permissions from the local or other body or authority in respect of any plans, drawings and specifications which have not been previously approved by the adjoining owner, provided always that if the adjoining owner shall improve the said the same, that the building owner should be required to modify or amend the same by the planning authority or any other authority, or if the building owner shall herself desire to amend, then no further application shall be made by her to any such authority unless the revised or amended drawings and specifications have first been approved by the adjoining owner. And then 3, no work shall be commenced upon the building site before the authoritative definitive plans, drawings and specifications of the said building have first been approved. So there's mirroring, it echoes what was in the 65 covenant. And then paragraph 4, 1, 2 and 3 of clause 3 of the said transfer shall here be abrogated. So that's excluded from the abrogation subparagraph 4, which was in the 65 deed, which was the positive covenant to build a wall. Now, although in the 68 deed there was, as you will have seen from paragraph 2 and to clause 2 and clause 3, there's a requirement for consent. It's not expressly provided that consent shall not be unreasonably withheld. In the first claim, when an application for consent was sought by Ms Hicks and went before Mr Miles, Queen's Counsel, sitting as a Deputy Judge of the High Court, he decided that those covenants in 68 are to be read as if subject to that qualification, consent not to be unreasonably withheld. So to that extent, it mirrors the earlier 65 deed. Now, I mentioned, drew attention to the positive covenant to build the wall, and as it's been, I believe, was indicated, that led the requirement to comply with that positive covenant actually led to litigation because the wall was not erected, and that led to Brigadier Radford, who was the original covenantee, suing on the covenant. But the original covenantor had by that time sold the plot, and so she in turn sued the her transferee on an indemnity that purchaser had given her. And those proceedings came before the High Court, before Mr Justice Oliver, as he then was, on the issue of the measure of damages. The question of liability wasn't an issue. So the court there decided how to measure the damages for want of compliance with the positive covenant. and the court's decision is reported in Bradford and Probraville. 12 years later, in 1989, a lease is granted at the respondent's flat number 5. A copy of the lease is at page 3. So page 13 of the tab 3, page 13 we have the recital of the demise, which is about a third of the way down. It's a demise for 99 years. The tenant covenants has a series of covenants, materially or relevantly at page 18, at clause 3.4. Page 18, clause 3.4. I find the tenant's covenant to pay what is called the interim charge and the service charge at the times and in the manner provided for in the 5th schedule here too. So the capitalisation of those terms indicates that they are defined, and they are, and you can see in the list of definitions, which is to be found on page 12. So starting with the interim charge, which is subparagraph 9 on page 12. The interim charge means such sum to be paid on account of the service charge in respect of each accounting period as the lessor or agent shall specify at her or their discretion to be a fair and reasonable interim payment on account. So it's an on-account payment. It's an on-account payment of the service charge. The definition of the service charge is provided in the preceding paragraph, paragraph 8. The service charge means 24.6 of the common parts expenditure and 19.83% of the general expenditure. Just pausing there, for the purposes of this dispute, the definition of common parts expenditure isn't relevant. So what we need to focus on for the purpose of this dispute is the definition of general expenditure. And that's to be found on the preceding page, page 11, under subparagraph 6. So you find there the definition of the general expenditure. So the general expenditure means the total expenditure, other than common parts expenditure as hereinafter defined, incurred by the lessor in any accounting period in, I'm going to say 1, carrying out her obligations under clause 4.4 of this lease, and 2, any other costs and expenses reasonably and properly incurred in connection with the building, including without prejudice to the generality of the foregoing, and then there's a list of expenditure running through to subparagraph E over the page. So within that definition, what I would colloquially label as there's 2 limbs. So there's the first limb, which identifies for the purposes of the service charge calculation the landlord's costs in carrying out the obligations under clause 4.4 of this lease. And then the second limb is any other costs and expenses reasonably and properly incurred in connection with the building, which includes, but not exhaustive list, it's an inclusive list, the items A to E. It is reliance on the second limb that is the subject of the application to amend. Reliance on the first limb was the subject of the dispute in the FTT and the Upper Tribunal. So the first limb, though, directs you to clause 4.4. Just before we look at that, it's carrying out her obligations under clause 4.4 of the lease. Relevantly, so clause 4, begins at page 18. So that's the operative clause, clause 4. So the lessor, with the intent to bind herself and her successors entitled, the persons for the time being entitled to the reversion of the demised premises, immediately expect on the lease, but not to bind herself in respect of any breach occurring after she shall have parted, hereby covenants with the lessee. So there is a slight disconnect with the language. So the definition of general expenditure refers to obligations, and here we're referring to covenants. The covenants that specifically that were and are specifically relied upon for the purposes of the first limb are to be found in subparagraph 4, firstly subparagraph G, page 22. And there it's G sub Roman 2. to employ all such surveyors, builders, architects, engineers, tradesmen, solicitors, accountants, or other professional persons as may be necessary or desirable for the proper maintenance, safety, and administration of the building. There's a list of persons, both technical and legal, whom the landlord has covenanted to employ as may be necessary or desirable for the proper maintenance, safety, and administration of the building.
And while we're here, we can conveniently note that the drafters of this lease were not shy of descending into quite small details. So in paragraph H, we've got to maintain the communal television aerial or aerials servicing the building, to pay all expenses in connection with installation maintenance thereof. J, to maintain any existing rented fire extinguishers and install such further extinguishers as the lessor may from time to time consider reasonably necessary and pay all charges in connection with the installation and maintenance thereof.
So that goes into some detail, absolutely. But what's quite jarring about it is it draws out only two specific incidents or two specific examples of what might otherwise be caught by the more general words above. Because if one thinks about contemplation, which is the way that Mr. Loveday puts it, if one is thinking about taking steps or employing persons, as may be necessary or desirable for the proper safety of the building, you might employ somebody to deal with a fire alarm. That would be reasonably contemplated in 1986. You would deal with you might employ somebody to survey or to advise on the replacement of fire doors or safety glass. So the extraction or the specification of a particular item doesn't inform on a narrow or doesn't encourage a narrower reading of G2. Because there are items which reasonably one would contemplate, objectively one would contemplate at the time of this lease in 1989, that would fall within the obligation under G2 or the covenant under G2. And so that deals, my lord, with the issue of extinguishers. Fire extinguishers would fall under safety. That's the point there. The proceeding called communal television aerials. Well, again, that is the maintenance of television aerials would be, as at 1989, objectively there would be contemplated a far wider range of items that would fall or would require maintenance. So again, by extracting for specification a particular item, doesn't inform or encourage a narrower reading of Roman 2.
So this may be caricaturing what you've just said, but are you submitting clauses 4, H and J are simply pointless? Because that seems to be the effect of what you're saying.
Well, no, not pointless. I mean, it's not an uncommon experience with the drafting of leases that there's a torrential style. What we're trying to do is seek to identify the meaning of Roman 2, relevantly as to whether it captures legal clause.
Yes, but on your submission, they are pointless because they have no effect, because it would all be covered anyway.
It's not that
so one asks oneself, why did the draftsman bother?
Well, to draw attention to particular items of expenditure, but does that, which I necessarily accept because they have been drawn out, but I don't say from that that you can construe or identify an intention that the employment of persons in connection with safety issues is limited is limited to things that could not be contemplated. And clearly, what they have identified in J is an item concerned with safety, and contemplated that work might be required in relation to that item. Now that supports what my learned friend says is the argument that the clause is the broader clause or the sweeper clause is limited to things that could not be contemplated. What I say, and I'll come to this with reference to what was said by the Deputy President in Asset Hold, is that actually the purpose of the clause is to cover things that aren't specifically contemplated. What J is an illustration of is something that's specifically contemplated. And the same point I say applies with when we move down to L. which is expressly identified as being without prejudice to the foregoing. So without, which I say naturally means without being limited by the foregoing. To do or cause to be done all such works, installations, acts, matters and things as in the reasonable discretion of the lessor may be considered necessary or advisable for the proper maintenance, safety and amenity of the building. So naturally that would collect or capture television aerials. It might be, whilst looking at these clauses, it is perhaps useful just to put into context what is I say there's a significant difference in the way that the respondent puts its case to how it was advanced in front of the Upper Tribunal, which does have relevance to how one reads in words to the argument. In the Upper Tribunal, paragraph 51, so page in the core bundle, which is tab 5, page 77.
Have you finished going through the lease?
My lord, there are, with the lease open, there are other clauses to come back to.
If it's more convenient to look at the Upper Tribunal now, by all means. But
Can I do that just to see what the Upper Tribunal said, then look at what Mr Loveday's argument is, then go back to the lease to say why it is relevant to the clauses. So it's at paragraph 51, page 77, tab 5. It's the final sentence. Clause 4.4 seems to me to have the same focus and purpose as a clause in issue in Ken Square and Boache, and that is the case, even though solicitors are referred to in 4.4G2. The clause is about management, and there is no hint of litigation. I agree with Mr Loveday's analysis. So it being said there that the tribunal finds there's no hint of litigation within clause 4.4, and relevantly the clauses that we looked at. Now, if we now turn to Mr Loveday's skeleton argument in this court, which is at tab 3. Page 49, paragraph 26. So 26, R's deal with paragraph 35 of A skeleton, subparagraph D. A is correct to say the parties would have reasonably intended and contemplated that the costs of litigation undertaken by A on the advice of experts would be recoverable through the service charge. This is expressly provided for in clause 4.4G2. So whilst in the Upper Tribunal it was being said that there is no hint of litigation to be found in clause 4.4, what is now being said is that the costs of litigation undertaken on advice are expressly provided for in clause 4.4G2. So going then back to the lease, and that's why I referenced it now, is because if we're looking at language and drawing out specificity, and go to G2, which is at page 22 of the supplemental bundle. Mr Loveday is right. It is captured by the clause, but it's not expressly provided for in the clause. What is being accepted and acknowledged there correctly, I say, is that the proper and natural meaning of the words captures that clause. Or in the language of Arnold and Britain, the costs clearly belong within that clause. In terms of the lease, whilst it is open, there are a number of other clauses that warrant observation. The first I would draw your attention to is clause 5, which begins at page 23. This is a lengthy clause which is concerned with the establishment of a tenant-run company. It's establishment through share structure. With an agreement recorded at subparagraph 8 on page 25, that after issuance of the shares, the lessee in conjunction with the flat owners will procure and or assist in procuring that the company shall purchase all the rights, title and interest of the lessor in the building subject to the said long lease to the flat owners. What clause 5 is a statement of intent to set up or to establish a lessee controlled company with an intention that the freehold title be transferred to that company. Again, whilst the lease is open, clauses that were considered in connection with the iterative approach to interpretation by the Upper Tribunal include the following. Page 14, there's clause 2.6. It's a tenant's covenant. Clause 2.6 at page 14. This is a clause that is commonly referred to as a Jarvis and Harris clause following the case of Jarvis and Harris. In that what it allows for is that where there's default on the part of the tenant in relating to its maintenance obligations, repair, decoration or maintenance, then it will permit the lessor to come on to the property to reinstate the same, and the lessee shall repay to the lessor forthwith on demand the costs of carrying out such repair, including solicitors, counsel, surveyors. And critically, for the purpose of this clause, such costs to be recovered by the lessor as if the same were rent in arrear. So that's a clause where there's mention of lawyers the cost of lawyers in connection with remediation work. There's no express mention of proceedings. The reason why the clause is there is to enable the landlord to recover the cost it incurs as a debt rather than damages, so as to avoid a procedure that's prescribed by the Leasehold Repairs Act of 1938. Over the page at clause 2.9, there's the forfeiture cost clause. 2.9, to pay to the lessor reasonable and proper costs, charges and expenses, including solicitors' counsel fees, at any time during the term incurred by the lessor in or in contemplation of any proceedings with respect to the lease under sections 146, 147 of the Law of Property Act, or any enactment or modification thereof, including in particular all such costs and expenses of and incidental to the preparation and service of notice under the said sections. That was a clause that was identified by the Upper Tribunal whilst we had the lease open. Just pausing there, this clause concerned with forfeiture. By reason of the Protection from Eviction Act of 1977, where property is occupied as a residence, you can't enter without court action. And so almost inevitably when dealing with a residential property, forfeiture will involve proceedings because you can't peaceably re-enter, unlike with commercial property. So the reference to proceedings in that clause is to be expected, because this being a lease of a residential flat, it is almost inevitable that there will be proceedings to exercise a right of forfeiture. Clause 4.3, which is now going back to the landlord's covenants at page 19. This is a mutual enforceability covenant. At the request of the lessee and subject to payment of the lessee of the costs of the lessor on a complete indemnity basis and provision beforehand of security thereof to enforce any covenants entered into with the lessor by any of the flat owners of a similar nature to those contained in clause 2.3. So it's a mutual enforceability clause. The landlord's saying, if you indemnify me, then I will enforce the like covenants that have been given by the flat owners. Just pausing there, there's no mention of lawyers, there's no mention of proceedings. It's to be read into the natural meaning of the word enforce. finally, and this clause wasn't identified in the but by the Upper Tribunal, but might have some relevance to costs, is clause 4.4n. So it's a clause that's captured within the service charge machinery. It's at page 22. And there it's to pay all costs and other expenses that might be incurred in the formation and administration of the company form pursuant to clause 5 hereof. There's an obligation to pay all costs for the formation and administration of the tenant, the intended tenant-run company to whom the freehold will be transferred. Following the grant of that lease in tab 4 in 2006, there was a surrender of the lease. Tab 4, you have a deed of surrender. Internally in clause 4 is the surrender of the lease, the unexpired term of the lease, in consideration of, over the page at 41, in consideration of a new lease. And the terms of that new lease, clauses 1, 2, and over the page at page 42, 3, there's the adoption of what I would call a shorthand approach, paragraph 3, to incorporate the wording of the terms from the earlier lease by reference and to avoid setting them out in full. It's as if the same were herein set forth. So that's the grant of a new lease. Over the next tab 5, in 2007, there's an extension, a variation of that lease. It's granted the 1st of June 2007. And over the page, at page 45, subclause 1, the purpose for the variation is to extend the term to a just shy of 1,000-year lease, 999-year lease. And it's not disputed that that deed takes effect as a surrender and regrant. The extension of the term of the 2006 lease has the effect in law, by operation of law, of surrendering that 2006 lease and there being a regrant. So that finishes the contractual documentation. The background to the disputed costs in this case is summarised in the appellant's skeleton argument in paragraphs 8 to 11, and they're not an issue. They're accepted by the respondents,
with a few minor additions and qualifications.
So the two qualifications is, one is the reference to the Radford case to which I've referred, and a clarification that the costs of the first claim are not an issue. So the costs that are in issue are defending the second claim, which is discontinued, the costs of the third claim, which was heard by Mr. Pelling, Queen's Counsel, at first instance, then went on appeal and then was remitted for a further trial, and the costs have incurred in objecting to Ms Hicks' planning application. So those are the three categories of costs.
I just want to, before we leave the lease too far behind, one area it seems to me you might say litigation must have been potentially in contemplation is the insurance clause. In that there are obligations on the landlord on the lessor to insure. It must be implicit that if there was a dispute with the insurers, there could be litigation.
Yes, as I indicated from the reference to the skeleton argument, it's accepted that it's implicit even within the relevant clause that litigation is contemplated. That is another clause, quite right, my lord, that identifies that you do not need express wording. The mutual enforceability clause, which we did look at, is another example because it talks about enforcement. There's no reference to lawyers. There's no reference to proceedings, but it's implicit, or I would say it clearly belongs within the clause because of the natural wording. The relevant question, the court will be aware that the question to be answered is what is the true meaning of the clauses. I just would wish just to take a moment to look at how the Upper Tribunal framed the relevant question, because there is an oddity which I'd just like to observe in the structure of the Upper Tribunal's decision. So the Upper Tribunal's decision's at tab 5 of the core bundle at page 70. So paragraph 24 at page 70, the issue to be decided is simply whether the lease entitles the respondent to demand the charges in question, incurred as they were, to fund the defensive proceedings against it by a third party, this is the second and third claim, and to fund legal representation, expert advice taken for the purpose of objecting to Ms Hicks' planning application in 2018. So that puts fairly and squarely, it's a question of interpretation. But having identified that issue, the oddity observed is at paragraph 58. So paragraph 58, I repeat that the respondent was entitled to refuse consent to the development, entitled to defend the legal proceedings. That's not the issue here. The issue here is whether the respondent was obliged to do so under clause 4.4 of the lease. So there is answering a different issue to the one that the tribunal framed at the outset. The correct question I submit is the one at 20. I would submit is the one at 24. But in any event, and this is why. When we looked at the lease, there's a disconnecting language between definition of general expenditure, which refers to obligations, and the reference to covenants. Now, it might be said, well, obviously they're one in the same. But as we've seen with clause 4.4L, it's in part exercisable by reference to a discretionary, the exercise of a discretion, the exercise of a reasonable discretion. That's in the wording of 4.4L. Now, that's not consistent with an obligation. Obligation requires you to do something. Whereas the wording of 4.4L strains with that, where it encourages or it conveys a discretionary exercise as to costs that might be incurred. But in any event, with reference to the clauses, which are conditional contractually upon their being necessary, advisable, or desirous, and that not being an issue for the reasons I'll come to in a moment, you get to the same point, because where it is necessary or advisable or desirous to take the obligation to carry out the step, then there's a covenant to do so. So you come back really in full circle. But either way, the relevant question here is not whether we were obliged to take these steps, rather as to whether the costs are within the meaning of the clause. As to that question of necessity, desirability, or advisability, as I said, the satisfaction of those requirements which are embedded within the two contractual clauses is not an issue here. It was an issue before the Upper Tribunal, before the first tier tribunal. And you can see that at tab 10 of the core bundle at page 122. There, the tribunal, it's the first tier tribunal, paragraph 28 at page 122, identified the issues for consideration relevantly subparagraph B. Do the sums fall within the category of costs which are recoverable under the terms of the lease? The applicants deny that the legal or professional costs incurred by the respondent in connection with the dispute fall within these clauses. Alternatively, it is contended that the sums are not necessary, desirable, proper, and or were not costs which in the reasonable discretion of a lessor were either necessary or advisable. So that issue as contractual necessity was an issue before the first tier tribunal. At paragraph 58 on page 134, in terms of the structure of their decision, there the tribunal confirmed paragraph 58, page 134, having decided the costs fall within the covenants. That's not the end of the matter, as to whether, because there is the question as to whether the costs were necessary, desirable, or proper, and or a cost which were in the reasonable discretion of the lessor, were either necessary or advisable. This is considered in our discussion of reasonableness below. So that consideration of that issue is picked up in the reasonableness section of the decision. And the findings on the point are at page 90, at paragraph 97, which is at page 145. Overall, in the tribunal's view, it cannot be said that it was not reasonable to incur professional fees in relation to the litigation with Ms Hicks per se. There were legitimate concerns regarding the proposed development, which in the case of the effect on the structure and safety of the building was shared by the applicants, even if they did not share the concerns regarding aesthetics. Similarly, as regard Ms Hicks' applications for planning consent, we note that the applicants were supportive of the objections to Ms Hicks' planning applications, and in any event, we considered it was reasonable for the respondent to incur professional costs in opposing the same. So that's its finding on the issue of contractual necessity. And paragraph 26 of the Upper Tribunal decision, which again is back in tab 5, paragraph 26 at page 70, there's the Tribunal's treatment of recording that finding. I record the FTT's findings of fact that the respondent consulted the appellants and kept them informed of the charges being incurred, and that there is no doubt about the respondent's motives, nor the legal justification for incurring the costs that make up the disputed charges. It acted at all times on the basis of legal advice and with advice from technical experts, and its concerns about the threat to the structure of the building, which the applicants shared, were valid. She then says, the tribunal then went on to say none of this is relevant to construction of the lease. Just before I come back to what that sentence means, there's an amplification of what the tribunal of the tribunal's findings at paragraph 50 of the Upper Tribunal's decision at page 77. In the first sentence, I agree that the respondents and the lessees were motivated by concern for the structural integrity and safety of the building, and that the respondent and the lessees, other than the appellants, were legitimately motivated by concern about amenity. So that is to put it in the context of the two clauses, that it was necessary or desirous in the interests of safety for the purpose of G2, or amenity for the purposes of subparagraph L. So when then one goes back to paragraph 26 and sees the final sentence of paragraph 26 on page 70, where in relation to those findings, the Upper Tribunal says none of this is relevant to the construction of the lease. Of course, it would be relevant if it was an issue, because it would be relevant to recovery to establish the contractual precondition of necessity, or the contractual condition of necessity, advisability, or whether the cost it was desirous to incur the costs. But because of the finding, there was no challenge to those findings. A consideration of that contractual qualification, a consideration of that contractual qualification, wasn't relevant to the issue of construction in this case, being the other elements of the clauses in dispute.
Can we just clarify exactly what you say is not now in dispute? Whether the relevant expenditure would have been necessary, desirable, or reasonable?
There's a challenge to reasonableness in the statutory sense,
Yes.
Which is as yet undetermined. But in the context of the language of the clauses in issue, so that's at page 22 of the supplemental bundle. So page 22, you have the two clauses. At the top of the page, G Roman 2, my lady. So there's a contractual qualification or contractual control on the recovery of costs, and that they must be or may be necessary or desirable. So I say the necessity or whether the incurring cost was desirable is no longer an issue in light of the findings of the FTT, which haven't been challenged and which are recorded. And similarly, for the purposes of subparagraph L, we have the exercise of the reasonable discretion of the lessor may be considered necessary or advisable. So what I say, the placement of those qualifications within the contractual recovery is not an issue, or the satisfaction of those requirements. The exercise of contractual construction is one that I'm sure the court's extremely familiar with. The parties refer to Arnold and Britton as one of the Supreme Court cases that dealt with the question of contractual construction because of what it said specifically about service charge clauses. In the bundle at tab 12 is a copy of the decision of the Supreme Court in Arnold and Britton. The relevant section on contractual interpretation begins at paragraph 14 on page 163 of the bundle, internal page 1627 of the report. Recognising the court's familiarity with that, it's really the focus is on what is said at paragraph 23, which is what concerns specifically interpretation of service charge clauses. So there it said, Lord Neuberger at paragraph 23, seventhly, reference was made in argument to service charge clauses being construed restrictively. I'm unconvinced by the notion that service charge clauses are to be subject to any special rule of interpretation, even if, which is unnecessary to cite, a landlord may have simpler remedies than the tenant to enforce service charge provisions. That is not relevant to the issue of how one interprets the contractual machinery for assessing the tenant's contribution. The origin of the adverb was in a judgment of Lord Justice Ricks in McHale and Earl Cadogan. What he was saying quite correctly was that the court should not, quotes, bring within the general words of a service charge clause anything which does not clearly belong there. However, that does not help resolve the sort of issue of interpretation of this case. So the point to be clear and of relevance to the construction issue here is that there is no special rule of interpretation to be applied to the construction.
Except that there is a special rule. The special rule is you don't bring within the general words anything which doesn't clearly belong there.
So there is a tension there. But it is correct to say, which is what I was going to say, that you cannot bring within general words something that does not clearly belong there. But what that does not invite, I would respectfully submit, is it does not invite through the back door a principle that the intended subject matter of a service charge clause must be or should be expressly stated. So the need for something to be to clearly belong doesn't invite the proposition that it must be clearly stated or expressly stated. And were that why there isn't that proposition is, or is there is no principle to that effect, is because to impose such a principle would be to read service charge clauses restrictively, which is precisely what Lord Neuberger disavows.
Well, if it just simply said, which does not belong there, it would be entirely unhelpful and anodyne, because ultimately what you're deciding is what belongs there. So what does the word clearly mean?
So that there's no ambiguity as to whether it belongs there, to remove the question of uncertainty. But it doesn't go so far as to require a clear statement of a cost, of a head of cost.
But when you say clear, I think you used it interchangeably with expressly.
I wouldn't say it's beyond doubt, because I don't think clarity is beyond doubt. The difficulty is to avoid synonyms and to replace the wording that was used by Lord Neuberger and import my own test. I think what I would submit is that when one goes through the exercise of interpretation to understand what it is that the clause is being directed to, it is once you've carried out that exercise and you can see what the clause or the nature of the cost is directed to, that then provides the answer as to whether the cost clearly belongs there. So I don't think, what I would submit is that it doesn't inform as to how you approach the question of interpretation. It's once you've exercised once you've interpreted the clause and what the meaning of the clause is, then from there you can obtain clarity as to whether the identified cost falls within the clause. And I say it in that way because otherwise, if you start with a presumption of clarity, is that you are then starting to import some special rule. I do recognise the tension perhaps within that clause that at the outset it says there is no special rule, but then says, well, something needs to be clearly belong there. But I think that what I would submit is that the reference there to clarity doesn't inform you as to how you approach the exercise of interpretation. What it does is once you have carried out the exercise in accordance with traditional steps and methods, you can then look back and say, well, now what I've identified the clause is aimed at, does this particular clause, the particular charge clearly fall within the four corners of that charge?
That's just a two-stage process of construction, isn't it? And the restrictive nature falls within the second part rather than the first.
Well, I suppose what I submit is the clarity comes from having identified what the clause relates to. So if there is uncertainty as to what the clause relates to, then there isn't clarity as to whether a particular expenditure might fall within its four corners.
But at the end of the day, the purpose of construing the clause is determined whether a particular item of expenditure falls within it. You're saying what you're doing effectively is breaking it into two stages, saying what does it mean, and then does this item fall within that meaning? You could just skip to the unitary question: is does this item fall within the clause?
Yes, and the reason I put it at that second stage is because to inform as to how you approach the exercise would then be to construe service charge clauses differently, which is what is disavowed in the first part of paragraph 23. There is no special rule. So the approach to the construction, there is no special rule that applies to the approach to the construction. But once you have approached the construction in a traditional way and identified what the clause means, you can then step back and say, right, does this item of expenditure, am I clear that this item of expenditure falls within the clause?
Okay, let me suggest the following interpretation of what Lord Neuberger's saying for your comment. Firstly, he's saying just because something is a service charge rule doesn't mean that there's any special rule of a service charge clause doesn't mean there's any special rule of interpretation. Same rules of interpretation that apply to other clauses and indeed other contracts are equally applicable. That is not a difficult proposition to understand. But then secondly, he's considering a problem which occurs elsewhere in the field of interpretation, but as it happens, is a particular problem with service charge clauses, which is when you have the use of vague and general words, and the question of what those vague and general words mean, and trying to interpret them in a way that doesn't cause nasty surprises. And that's what he's getting at when he approves what Lord Justice Ricks said. What would you say to that?
So my submission is that does invite that two-stage test. It puts it more eloquently than I was, but it does approach it from that two-stage test, because there is a unitary exercise, Lord Phillips said, which is that you just carry out ordinary contractual interpretation. But once you've identified it, you then look at the nature of the cost, and does it clearly belong there, or is it a surprise? Would it be a surprise to say this particular item, to adopt your lordship's terminology, would it be a surprise, an uncomfortable surprise, to somebody to say, well, actually on that wording, this clause comes out because I can't see that it falls within the four corners. But it doesn't require any additional or alternative approach to the ordinary exercise of interpretation. Look at the natural meaning of the words, look at the iterative exercise. It doesn't require you or presume that you start from any, or you're looking for anything, any particular wording, or that it requires any, materially here, any express wording.
All right, where do we go next?
Just pausing there, and I think this is why what is said at paragraph 26D of the skeleton argument is illuminative, because it is accepted that the cost of litigation that is embarked upon on advice is expressly within the clause. And for it to be recoverable under the clause, there's an acceptance that it clearly belongs there. was said by the deputy president in the case of asset hold is perhaps apt, which is at tab 11.
Yeah, now, just before we get into the details of asset hold, can I ask you this question? It's not binding on us. And therefore, how much do we get out of this? I mean, obviously, in our case, Judge Cooke was understandably exercised with asset hold because of the general principle that courts of coordinate jurisdiction should follow each other's decisions unless clearly convinced that they're wrong. So she was starting from the position that she should follow asset hold unless either she was clearly convinced it was wrong, and she wasn't, or it was distinguishable, she thought it was. But in this court, none of that is of any concern to us. All we're concerned with is what's the right interpretation of the specific words with which we are concerned.
Yes, but they need to be considered. One of the exercises is to consider the purpose of the clause.
Indeed.
And asset hold does, or the deputy president in asset hold identifies what he considers to be the purpose of a generally worded service charge provision.
Right. So you're praying this in aid as a general consideration recognised by someone who is expert in the field.
On that particular issue, in seeking to understand what Lord Neuberger meant and recognising that this predates the Supreme Court's decision in Arnold and Britain, it does, in my respectful submission, make some useful observations as to the distinction between express language and the need for clarity.
Well, if you're relying upon the authority as something that is relevant to principles of contractual construction, then I have a lot of problems with understanding how you can possibly do so when we are bound by what the Supreme Court said.
Yes.
If, on the other hand, you're putting this forward as a view from a specialist tribunal as to particular considerations which are relevant within this field that are legitimate to take into account, then that's another matter.
The focus of my submission does come under the section on purpose.
Right. Okay.
Because it does specifically, I say, the Deputy President does specifically deal with that in paragraph 58.
All right. 58.
58 and 59.
Shall we read those two paragraphs to ourselves?
Yes, thank you.
So what do you get out of those two paragraphs in this sense? That if what the Deputy President said is at variance with what the Supreme Court said, then it's of no effect. We have to apply the Supreme Court. If it's the same as what the Supreme Court said, then it adds nothing.
Okay.
So what do we get out of this?
So so paragraph 58 is that so it's not the principle of interpretation, but where language which clearly intended to encompass it. So this is that's 7 lines down. Language intended to encompass expenditure in a wide variety of situations which the parties have not explicitly catalogued should be so restrictively construed as to deprive it of any real effect. But I say it's a function of this type of clause is to avoid explicitly cataloguing every variety of situation. So that's a purpose of the clause.
Okay.
And then there's a second, I would say it is twofold. The second fold is at paragraph 14, about halfway down. Sentence beginning a general provision. General provision such as paragraph 6 is included in the lease precisely because the parties appreciate they cannot anticipate all eventualities. The parties must be taken to expect that an agreement intended to last for 125 years, circumstances may arise which they do not specifically contemplate at the time of contracting, and in which expenses by the landlord may be necessary or desirable in their mutual interests. Probably appreciate from reading the clause, the case of what was said in the tribunal, but the paragraph 6 is to all intents and purposes identical to clause 44L in this case.
Mhm.
So relevant to the exercise of interpretation is to construe the words in the context of their purpose. The purpose of this of a clause of this nature, or the nature that we've been looking at, I say, is twofold. One is to avoid the explicit cataloguing of a wide variety of situations, and secondly is to meet the difficulty the parties cannot anticipate all eventualities. So the clause caters for the circumstances that they do not specifically contemplate. And those two functions complement each other because it avoids having to list all that they do contemplate, but whilst also preserving recoverability of those which they do not specifically contemplate. And coming back to the observation my lord made about the drawing out of specific items of expenditure within paragraph H and J in the service charge clause, the placement there, in my respectful submission, is a strong indicator that the purpose of the clause is to have that twofold function. And it comes back to what I was saying, what I submitted before, that there is objectively other safety expenditure that could be contemplated. They specifically contemplate fire extinguishers, but it doesn't mean that they're not contemplating anything else. The purpose of the clause, because there's a wide variety of circumstances which may engage safety or amenity, the purpose of the clause is to avoid explicitly cataloguing everything that might fall within that the range of circumstances.
It does suggest that the TV aerials and fire extinguisher clauses are complete surplusage, which is contrary to the proposition that one starts by assuming that all provisions included in a document are there for a purpose and must be given effect to.
Which brings you back, but that then begs the question as to what the purposes of these broadly drawn clauses are, because one has to give them meaning.
To be sure.
But another possibility is, apart from surplusage, is that their existence indicates the potential scope of the general words. In other words, that the general word should apply to maybe things that are similar to those items specified.
So yes, the difficulty there, though, in my respectful submission, is the placement of solicitors in clause 4G2 specifically, point 1, and point 2, the acceptance that that clause expressly caters for the cost of litigation taken on advice. And so, lady, the reference to safety cannot be, in light of that acceptance, the word safety is found in 44G2, can't be limited to items of the nature of a fire extinguisher.
Well, unless you're suing the company who installed your fire alarm system. There's a whole range here, isn't there?
Yes, but there is, having extracted only one example of something that might be related to safety, having not it would be to ignore the natural meaning of the word, that to employ a solicitor in connection in relation to the safety of the building would not capture something an issue to do with subsidence. It still jeopardises the safety of the building. That falls within the natural meaning. And by if costs incurred in taking litigation on advice is captured by 4G2, it clearly belongs there. And there's nothing within the wording of the clause to differentiate between different types of litigation, so long as they are concerned with maintenance, safety, or in the clause case of 4G2, administration. So as long as the subject matter of the advice that's taken or the action that follows the advice is directed to those three considerations, maintenance, safety, or administration for the purposes of 4G2, then there's nothing in the language of the clause to draw bright light between certain types of litigation and not others. So, for example, if it to be said, the Upper Tribunal's decisions, there she was saying, the Judge Cooke said there was no hint of litigation. I would say that's respectfully wrong, and it appears to be accepted it's wrong. But it doesn't differentiate, in the language, you can't see differentiation between litigation against any class of person, a third party. You know, objectively, if one stops and contemplates the issue of safety, the safety of a property is going to be subject to external influences. To the contrary, I would say is that the natural meaning, once it's accepted correctly that litigation falls within the scope of the clause, the natural meaning of the words does capture litigating against third parties. Whether that might be a neighbour, whether it's a private neighbour, or whether it might be the highways authority to whom you neighbour. And where you have already within the framework of the lease under the forfeiture clause, a clause that enables enforcement action and cost recovery against the default of the tenant to whom the lease applies, then the breadth of 4G2 can be seen in that it's naturally applying to other parties, because there's already a machinery and mechanism within it for litigation, enforcement, cost recovery against the tenant who is the party to the lease. And with reference to 44L, that applies really to both clauses, but naturally, acts, matters, or things necessary for the proper safety captures, I would respectfully submit, taking advice. Taking advice on a matter that requires whether maintenance is required. Taking advice on whether an issue of safety is raised. Supplementary bundle, page 22. So page 22, without prejudice to the foregoing, to do or cause or to be done all such works, installations, acts, matters, and things that in reasonable discretion of the lessor may be considered necessary, advisable for the proper maintenance, safety, and amenity. The natural meaning of those words, I would respectfully submit, encourage or capture taking advice. Now, starting with that proposition, there's nothing within the wording to say, well, once you get the advice and the advice is to take a particular step, that somehow the cost recovery stops.
Well, if the building burnt down, and there was a huge insurance claim, and the insurers refused, for some reason, to accept liability, or refused to, or were only willing to pay a small fraction of what was sought, it seems that, I mean, you would say that it's obvious that you would take advice as to the nature of the coverage and the nature of remedy, and the landlord would have to, the lessor would have to bring proceedings against the insurer, and all that would be included.
So long as it falls, the control, the degree of clarity is to be found. It's not so broadly worded as to be for want of any clarity. The clarity is that it's got to be directed to one of those three issues. So as long as the advice is taken in connection with safety, maintenance, or administration, or under L4 issues, maintenance, safety, amenity, and administration, then the taking of the advice, yes, I do say, is naturally within the corners of the covenant.
Well, enforcing insurance rights in order to rebuild or repair, and seems to me it would be very strange if the lessor could not, and indeed was not obliged to carry that out.
So then that would then be concerned with, well, it's concerned both with the safety and the maintenance, the building being in a dilapidated condition.
Assuming it falls within all of those heads, and it might entail quite lengthy and expensive litigation.
Yes, and I agree and I respectfully adopt that. Just to pick up on the point about the expensive litigation, because that's the point that's made. Well, it's almost a case of putting the cart before the horse, because the quantum of the cost can't inform the principle. You can't say, well, now that I know what the costs are, it can't have been contemplated. It wasn't the intention that, or wasn't contemplated that you would embark upon this litigation, because the quantum's the product of the principle.
Yeah. But you make the insurance claim, the insurers come back and say that there was, for some reason, a right to decline coverage, non-disclosure, or some act of God, or whatever, terrorism, whatever defence they deploy. Plainly, in the first instance, there would be correspondence, which would no doubt be conducted by solicitors. Not necessarily particularly expensive in that context, but how far does it go? And maybe I'm misunderstanding, but I thought your case would be that it would be that the lessor would be obliged to pursue it all the way through to seek to obtain a judgment.
Yes, you can't.
In those circumstances.
Yes, in the same way to bring it back to I agree with that analysis, but to bring it back to the present case, somebody says, I wish to build on my neighbouring plot, and you have the benefit of protection. The property interest is protected. And so you take the advice as to how will this plan affect my property interest, and you're being told on expert advice it's going to affect your amenity, going to affect your structure. Well, following that advice requires putting in a refusal of consent. That's a natural step in consequence of the advice you've taken. But at that point, it's out of your control as to what litigation follows, because it's then in the hands of the other party as to whether they wish to. But that's a necessary or an inevitable consequence of you taking the original step. And once then that litigation is embarked upon by the requesting party, so that's for declaration that consent has been unreasonably withheld, it doesn't fit naturally in the words to say, well, at that point, you've got to stop. You can't defend your decision that you've taken on advice. Because the step that you are taking in defending the action naturally follows from the advice that you've been given. And you don't have certainty at the outset as to what your cost exposure is going to be, but that's an inevitable consequence of the uncertainty in litigation. nobody sitting here would say, well, you're going to have a trial, the judge will get it wrong, we'll go to the Court of Appeal, you'll then have to go back and have another trial. Or to illustrate, again, with reference perhaps to a related service charge field, the case of Dejan and Benson about service charge consultation, it went in front of the Upper Tribunal, in front of 3 members who made a decision. It went in front of 2 judges of the Upper Tribunal, one of whom was at the time Lord Justice Calmouth, who agreed with that decision. It went in front of the Court of Appeal with 3 judges who agreed with that decision. It went in front of the Supreme Court with 2 Supreme Court judges who agreed with that decision. But critically, 3 of the Supreme Court didn't. But when you're at the outset embarking upon litigation, you don't know it's going to go on that long, and you can't predict those costs, and you're more uncertain as to what the outcome is going to be. So the uncertainty of litigation is a product of the principle that is a product. It doesn't inform us to the principle. It's a product of the principle because it's inherent within litigation itself. And there's nothing particular once you accept that the costs of litigation taken on advice is recoverable. Then there's no reason with reference to quantum to differentiate between different types of litigation. There's no reason in principle to say, well, litigation against the third party is going to be any more costly or incur any further or any additional delay. Just picking up on the point about the insurance, it's the contractual control is the necessity or the desirability, and so you ask yourself those questions as to whether it's necessary or desirable to press the insurer or to litigate with the insurer. I suppose again that makes little difference to the position here where you're operating on advice. As part of the So I say that in terms of the natural meaning of the words, there's nothing to indicate why costs are expressly covered in 4G2 as its common ground, but not under 4L. The distinction, I see the distinction that it identifies particular groups of advisor or individuals, but with reference to the purpose at L, which is to introduce a clause without limitation to what's gone before. Naturally, the taking of advice falls within L. And again, you come to the same point, which is that naturally, once you've taken advice, it would be perverse not to follow that advice. Just sticking with quantum for a moment, of course, if one starts analysing the principle with reference to a quantum, you invite a threshold criteria, and it becomes. Once you have a threshold criteria, it becomes unworkable because you can't predict what the costs are before you embark. And once you do embark and you reach that threshold, you're left with the invidious position of having to decide whether you pull out, which will almost inevitably be at an additional cost, which necessarily will take you above the threshold or not be recoverable, or continue with the litigation beyond the threshold, recognising that the cost won't then be recoverable from the service charge. And that concern is all the more real in a case such as this, where part of the factual background is an intention to set up a lessee-run freehold. So there is, at the outset of the lease in 1989, it is envisaged that there will be a transfer to the freeholder will pass into hands of the leaseholders. Now, I say that is part of the relevant background. I'm not saying that I wouldn't submit that it introduces some presumption of service charge recovery. But the vulnerability of the existence or the intended existence of a lessee-run freehold company is part of the relevant background which can't be ignored. And now, objectively, there's desirability for that landlord to be able to recover its costs.
But you could argue that either way, couldn't you? If it's contemplated that there would be a lessee-run company, then it's contemplated that the lessees together would control that company and could make decisions about what they wanted it to do, possibly outside the terms of the service charge provision.
Then you run into difficulty with the, I agree with that. The difficulty then is how you fund, because it's then reliant upon agreement and voluntary contributions. So if you, in the moment that you end up in division, so the company decides in accordance with corporate law to take a step because it's necessary, desirous, but one individual says I'm not going to pay, then you immediately face the shortfall.
Well, not necessarily. It depends on whether the others choose to fund it.
Or to meet the difference.
And so we come to the crux of this appeal, which is whether the majority can enforce their will against the minority. And that depends upon their contract.
Well, I was going to say it's not. It's the product of the decision, not informing what the decision is.
No, but that's the context, isn't it?
But you do have the in the broader context, yes. But for the specific costs that are challenged here, you have the finding of agreement that steps need to be taken in the interest of the structure of the building and the safety of the building.
Well, there was agreement up to a certain point, but not beyond.
Yeah.
Yeah. So where do we go next?
What we haven't spent any time looking at, and it is drafted in broader terms, is the second limb of the general expenditure clause.
Right.
So that is at in the supplemental bundle. And it's at page 11. And it's paragraph 6 of the definition section. The second limb captures any other costs and expenses reasonably and properly incurred in connection with the building. So it doesn't have the same degree of specificity as the other clauses that we looked at, but it's not wholly without limitation. And relevantly, I would submit is that in relation to the words there, in connection with the building, is the provenance of these clauses, the provenance of these costs, which was in connection with restrictive covenants that were given specifically for the building. That's what was held in the Court of Appeal in the Hicks litigation. That it was the building that benefits from the covenants. You can see that in the head notes of the Court of Appeal's decision at tab 18 of the authorities bundle. Just reading from the head note, tab 18 at page 267, that the true principle was that where a covenant provided that the covenantee's consent was not to be unreasonably held, the covenantee was not entitled when deciding whether or not to grant such consent to take into account matters that did not affect the land with the benefit of the covenant. That therefore the starting point was to identify the land for the benefit of which the covenant had been given. That, in the present case, the covenant had been expressed to be for the benefit of the building as a physical entity and not merely the property interests in it. When then taking steps or taking action in connection with the benefit of the covenant, there is communication or correspondence, I say, between that step and the wording of the second limb of paragraph and the definition of general expenditure, is that it is action in connection with the building, because it is the building itself that benefits from the covenants. it said in response that those clauses need to be read in conjunction, limited to management under the principle of justum generis. My respectful submission is that the genus, if anything, is the building. It's not limited. There is nothing in the language there that the genus of the service charge recovery is management. We see that as it's part of the definition of general expenditure that through 4.4 captures safety, administration, which may be to do with management, but also amenity. One of the factors that the Court of Appeal, the Upper Tribunal alighted on was its determination that the focus of these clauses was management. But there's the word management itself is not to be found in these clauses. It's not found in the second limb. It's not found in either clauses 4G2 or 4L. And accordingly, it doesn't fall within the class of case, for example, the Ken Square and Boache, which was decided in this court, or the number 1 West India Key, where they were looking, the court was concerned with the recovery of costs of defaulting tenants and whether that was costs of management. Now, naturally, as a natural meaning of the words, it doesn't, such costs don't fall within management. But that's not the same to apply here, where there's any reason to limit safety, amenity, and maintenance to acts of management. I mentioned, I made the submission that from the appellant's perspective, a relevant piece of the factual background is the intention to set up a corporate, a lessee-run company. On the other side of the fence, the respondents say, well, the Radford litigation is an important part of the factual background to inform as to the meaning of these clauses. It was said by the Upper Tribunal at paragraph 56 that the plot is a much litigated piece of land. I respectfully say it's not a fair characterisation. There was a piece of litigation concerning it. It concerned a very different aspect to the Hicks litigation. It concerned a measure of damages for breach of a positive covenant, not a request under a restrictive covenant and a consequential challenge to the reasonableness of the refusal. The other feature too is it's just in terms of its timeline, it is too, it's not sufficiently proximate to the grant of the leases. It occurred the singular case.
Can I be clear how far you go? Are you submitting that Radford and recoverable is irrelevant?
No, what I would submit is that it's been given too great a prominence in the Upper Tribunal's reasoning as an indicator.
Well, forgive me for being picky, but at first blush, a background fact is either relevant or not relevant. You seem to be pitching it as somewhere between the two.
I would submit that it being litigation concerning a neighbouring plot, I can't say that it has no relevance, but it is a question of what weight is to be given to it as an indicator of intention.
Right, so you accept that it's a relevant background fact. And you've made it clear that your submission goes to weight, but can you help us as to exactly what you say is given that it's of some relevance, is the right way to treat it?
It doesn't, in my submission, carry weight as an indicator of intention. I do say there is a distinction between saying something in the same way that whether something is admissible or not doesn't mean that you give it weight. The cherry tree, the contractual interpretation of registrable interest is an example of that. As to matters for the exercise of construing a registrable disposition, whether reference can be or regard be as part of the admissible facts have regard to something that is not on the register. What Lord Justice Lewison, I think, accepted was that it's admissible, but no real weight would be given to it. So there is something can be relevant, but without any real weight being given to it. And why no real weight should be given to it here is because it does form part of the background, therefore it has some relevance. It has no weight because it concerns a different type of litigation. It isn't sufficiently proximate to the contracts that are in the lease, either in 89 or the regrants in 6 or 7. And logically, it's where does it take in terms of informing as to intention? Because it's accepted that litigation is called. So it's effectively, it has to be said that because it is not, there isn't with reference to the Radford case, litigation, the piece of litigation, because there is no specific reference to litigation express reference to litigation involving that property, you can't bring it. You can't say it was intended that the clause extended to capture the Hicks litigation, because here is a piece of litigation involving that property. I accept, says the respondents, that litigation costs are recoverable as a matter of principle under the clause, but not the Hicks litigation, because here was a previous piece of litigation, and you haven't, in light of that, you ought to, had you intended recovery, to expressly mentioned litigation under that deed. That, in my respectful submission, brings back into play the proposition that you need express words.
Even if there hadn't been the Radford litigation, the existence of the covenants and the fact that the land was as yet unbuilt on was itself irrelevant.
Yeah, I couldn't say that the deed itself doesn't have relevance, or its existence as a relevant fact, but that doesn't require specific mention because of the purpose of a clause of this nature, which is to capture a wide variety of circumstances. Because necessarily living in a built-up area, it can be contemplated that you will have disagreements with your neighbours.
Well, no, it goes a bit further than that, doesn't it? Because there is a specific requirement in those covenants to seek consent. Yet nothing in the leases that is directed to that.
Well, nothing express. Save to the extent that, and recognising it's broad words, save to the extent in the second limb where it refers to steps taken in connection with the building, and as I've already submitted, the benefit of the covenant being the building itself. But I accept that there is no express reference to litigation or taking advice on any request for consent, but I would submit that brings you back to looking for express wording, which is not the exercise. Why is it if litigation costs incurred on litigation having taken advice are recoverable under G2, where within the wording can we clearly say costs of doing that exercise but with Ms Hicks doesn't fall within G2? Having accepted the principle that cost of litigation taken on advice is recoverable, there's nothing that then stops or creates bright light at the point where you say, well, but the litigation's with Ms Hicks. I've addressed you the remaining exercise as regards commercial common sense and its placement in the exercise of interpretation, it has relevance where there are rival competing meanings. Here, the focus for commercial common sense is it really focuses on the question of quantum and the question of costs. But that's looking it through the prism of hindsight. And I've already made my submissions on costs, so I won't repeat those. But once you accept the principle that litigation costs are recoverable, it can't be right to say, well, the recovery becomes absurd or not intended if they reach a certain level. That's repeating the point I've already made. It's about the quantum of the cost is a byproduct of the principle that you can embark upon the litigation. Two points raised by the respondents is that the absence of any other cases in the trawl of the FTT where this type of issue might have arisen doesn't take us anywhere, it doesn't inform, because all that would do is identify, all that does is identify there's been no challenge to such costs. And in terms of the reference to the code, I'll listen to what Mr. Loveday says, but I struggle to understand its the RICS code. I understand its relevance because it's nowhere in the document as it said that it's to supersede or take primacy over what the lease requires. So it doesn't inform as to the meaning of the covenants in the lease. The iterative exercise of comparing, looking within the four corners of the document and looking at other clauses to see whether that informs, in my respectful submission, it doesn't assist here. One, because it's accepted that litigation costs are recoverable, but two, the clauses that we looked at, some include lawyers or proceedings expressly, others by inference. So it doesn't. In this case, there's nothing in the surrounding clauses to inform the exercise. May I just take one moment? Mr. Blakeney quite correctly reminded me, it was said by the Upper Tribunal, it's a point that runs off of quantum, that because costs are uncertain and can keep going, that leaves the flat and the freehold interest as unmarketable. And that is an outcome which informs that it cannot have been intended that litigation costs be included. As I say, the answer to that is in part the acceptance. But in any event, there's no evidence as to the marketability. It's just a pure exercise of speculation. And really, it cuts both ways because to the extent that costs can't be recoverable, then you don't take action. In the event that you don't take action, that affects the marketability of the interest itself. So, for example, if there's a request for consent, but it said, well, you can't recover the costs, then you don't respond, then the inactivity itself affects marketability. So, one, there's no evidence, and two, it doesn't inform the inquiry. Unless I can assist you further on the substantive questions of interpretation.
No, thank you.
There's just then the extant application to amend to rely on the additional reason.
Yes, can I be clear as to what exactly you're applying to do? And it may be I've misunderstood, but if I've understood correctly, what you're seeking permission to do, I think it's two things. And I'm not sure there's really much difference in terms of the effect, but nevertheless, I think you are trying to do two things. One, you're applying to amend your client's statement of case, and secondly, to raise a new point on appeal. Have I got that correct?
Yes.
Thank you.
those are the two things. What I would say they follow it. The sequence of them is to ask for permission to rely on the new point. Hudson and Hathaway was an example where a point was taken without any requirement to amend a statement of case. It was a point of law. I say this is a point of law. So I do ask for permission to.
Well, it's a point of law in the sense that there's a question of interpretation of the lease. But the ambit of the dispute is defined by the statement of case. The statement of case tells us which clauses are relied on. And currently, this one isn't, as I understand.
It's not pleaded. No, I agree.
And that's why I framed the question as involving those two aspects.
Yes.
I mean, let me be clear. If you have a submission to the effect of you don't need to amend your statement of case, by all means let us have it. But at the moment, I'm a little unclear as to why that would be so.
Well, what I would, Hudson and Hathaway is an illustration of a case where a new point was taken, a point that hadn't been pleaded but would be pleaded to identify the issues in the case, and it wasn't an impediment to the point being taken that there was no pleading, and there was no suggestion that there even needed to be a retrospective amendment to the pleading.
Well, that may have been what happened in that case, but as a matter of general principle, courts don't allow unpleaded points to be taken for the first time on a second appeal, at any rate without an amendment.
Save in that case, which was a second appeal where a new point was taken.
Well, if there's some principle you're getting out of that case, as opposed to that's what happened, by all means let's look at it.
There is no I accept there is no consideration in there as to, because it didn't come up for consideration as to the need for an amendment. There is no consideration in Justice Lewison's judgment as to the placement of an amendment within the analysis. In other words, whether it is a condition precedent to taking a new point that you need to amend your statement of case. But what I would submit is this, that the considerations for allowing the amendment, allowing reliance and the amendment overlap. And it's because the considerations as to whether it's permissible to take a new point would have relevance or central relevance into a question of whether it's permissible to amend the statement of case, whether it would require the degree of prejudice, whether it would require additional evidence, a rehearing on evidence, whether the point is taken at a time which enables the responding party to deal with the point, whether the point is a pure point of law that is not contingent or dependent upon evidence or additional evidence. And so my respectful submission that the two applications go hand in hand and are the same considerations.
Okay.
The principles as expressly applicable to an application to raise a new point are not an issue there in Singh and Das. To an extent, they were amplified by this court in Notting Hill Finance. Perhaps worth just looking at what was said there at tab 16 at paragraphs 26 and 27. So it's the authorities bundle, tab 16. 26 and 26, 27, 28. internal page 240. So having cited the principles taken from Singh and Das at paragraph 25, so then 26, 27 and 28.
All right, we'll read those paragraphs ourselves.
So the amplification is one, that there's no need for the case to be exceptional, and that there are the recognition that there is a spectrum of cases. What I would submit is that, and I'll come on to my list of submissions, is that we fall within this end of the spectrum where it's what I say is a pure point of law that can be run on the basis of facts as found by the judge. That's paragraph 28. Hudson and Hathaway merely adds to that to confirm that there is no bar in principle on the point being taken on a second appeal. That's at paragraph 38. But the underlying submissions, it's clearly fact sensitive. The underlying submissions are these. The new ground concerns only a point of law, so it's the construction of a lease provision. It's a point, I would submit, that originates from the same starting point as the existing arguments. Does the lease allow recovery of the relevant costs? The point does not require, and it hasn't been suggested that it requires any further investigation of the evidence. The point involves a little variation, if any, to the case which the respondent already has to meet. It's a short point of construction which substantively the respondents deal with in 3 paragraphs. And the arguments are an extension of those that are all already made in relation to the 2 clauses relied upon. Properly analysed, there really is no identifiable detriment. It doesn't broaden the grounds in any real sense. It remains a case about the construction of a service charge clause. Relevantly, there is nothing to indicate that had the point been raised earlier, the respondents would have approached this case differently. On the substantive question of whether the clause allows recovery, they continue to resist the appellant's case. There hasn't been any delay to prejudice the respondents. They've been able to adequately deal with it in their skeleton argument. There is a broader utility point, which is that there are further costs in connection with the Hicks litigation that are not the subject of the current proceedings. And that's because they were raised relate to periods after the application to the FTT. So in the event that this court upholds the Upper Tribunal that says the costs aren't recoverable under 4G2 or L, then considering whether they're recoverable under this second limb goes some way to avoiding further litigation. Identifying whether there can be reliance on that clause for purposes of the cost recovery furthers rather than hinders finality of litigation. It's not part of the analysis as to why the point wasn't. It isn't part of the analysis or part of the principles for there to be a good reason why the point wasn't taken below. That finds no placement in either Singh and Das or the Notting Hill Finance case. And in Hudson and Hathaway, Lord Justice Lewison expressed himself as being unable to understand why the point wasn't taken below. To the extent that there is a reason, we don't know what it is. The appellants were represented, relied on their legal team, different legal team at the time when the case was pleaded. So what we submit is that permission to take the point is consistent with the principle, doesn't offend the principles in Singh and Das, and for the same reasons, it is appropriate and inconsistent, or doesn't undermine the overriding objective for the purposes of giving permission to amend. So those are my submissions on those two applications. I apologise for this. Then there is just two points just to go back to on the, if I may, on the substantive point of construction. I apologise for this. One, I'm going to ask a question because I won't trouble you if it's not going to persist. As you rightly identified, my lord, the Upper Tribunal sought to distinguish asset hold. I say the reasons were just unjustifiable for the point of distinction, but that doesn't get us anywhere because it merely brings it back into some relevance, but it has no relevance for the purposes of this court exercising its interpretation for the reasons that you've identified. So I don't, unless it will be of assistance, I don't propose to trouble the court as to why we say the distinction.
It's an academic question for us.
I did mention, and finally, I did mention in submission that the tribunal, the Upper Tribunal in its reasoning, placed reliance upon the Ken Square and Boache case. That was a case, and I mentioned in submissions that
well, that's more pertinent because it's a decision of this court.
It is. So I just wanted to look at what that case concerned. So it's in the bundle, authorities bundle, beg your pardon, paragraph 21.
Yeah.
What the we already looked at it, so I won't trouble you again. I'll just read it out. It's in paragraph 51 of the Upper Tribunal. What the Judge Cooke says, clause 4.4, so that's in our lease, seems to me to have the same focus and purpose as the clause in issue in Ken Square and Boache. So the clause in Ken Square and Boache is at paragraph 11 of the report, page 341. So what was being said by Judge Cooke is that the clauses that we've looked at in our lease are have the same focus as the clause in Ken Square and Boache. In Ken Square and Boache, the clause is expressly focused on management. It is more limited in scope, expressly more limited in scope than the clauses of the nature that we're looking at in our case. There, the focus is on the word management. In our case, we have a broader range of consideration: safety, amenity, maintenance, administration. So with reference to the natural meaning of the words, we can't say that the clauses are the same. The costs that were an issue in this case were the landlord's costs of pursuing a defaulting tenant. So it was being said that through what was being claimed through the service charge was the right to recover, that the service charge paying tenants would have to pay the landlord's cost to the extent that they weren't recovered from the defaulting tenant for pursuing somebody who did not comply with their contractual obligations.
Why is that not more obviously concerned with management?
Well, so the reasoning, so the court found that it wasn't.
I realise
So, yes.
that. So I'm posing the question.
Because it came back to the Arnold and Britain point, it didn't clearly, so the reasoning is at beginnings at, well, the section begins at paragraph 45, but the reasoning is at paragraph 52.
I think you mean 53.
53, sorry.
Yeah.
in that reasoning, Lord Justice Neary refers to what was then a fairly recent case of number 1 West India Quay. And the clause of that can be seen on the preceding page at 356 towards the top. The indented paragraph being the reasonable and proper fees and disbursements. Again, it was costs incurred in pursuing defaulting tenants. So the court in Kent Square didn't reach the same conclusion as number 1 because number 1 had reached that conclusion. It decided on the basis of the natural meaning of the words, which were focused on management, did not capture litigation. The number 1 West, although it doesn't follow number 1 West India Quay, it's consistent with the outcome of that case. As one can see at the top of page 356, part of the reasoning for number 1 West India Quay was referenced back or harking back to Cellar House case, Cellar House and Mears. Cellar House and Mears is at tab 4. Cellar House and Mears, the clauses under consideration were at the bottom of page 52. With 2 clauses that were relied upon for the purposes of recovering costs from a defaulting tenant. So one was the employment of a managing agent to manage. And then secondly, at the top of the other page, to employ all such surveyors, builders, architects, engineers, tradesmen, accountants, or other professional persons as may be necessary and desirable for the proper maintenance, safety, and administration of the building. Which echoes our case without the inclusion of solicitors. The findings of the judge in that case, the judge at first instance at page 53, paragraph beginning, the learned judge, in relation to J1, that relates to the management of the building. He then said in words in J1, including the cost of computing and calculating the rent and service charges, clearly referable back to the words of the managing agents and chartered accountants and do not contemplate the fees of solicitors and counsel. In relation to J2, the judge said that the words or other professional persons must be related to the proper administration of the building. The words do not appear to the judge to cover legal proceedings for possession or arrears of rent. So that was the judge at first instance. In the Court of Appeal, the conclusion of Lord Justice Dillon is over the page at page 54. I've had certain hesitation on this point in the light of the argument in relation to the position where solicitors are instructed by the managing agent. It does not appear from the evidence whether that was actually the case. On the whole, however, I've come to the conclusion that the judge was right in his view that the fees of solicitors and counsel are outside the contemplation of either limb of clause 5.4J of the lease. And Lord Justice Taylor, I agree. I had only a few words on the issue whether legal fees can be included in the service charge under the lease. Nowhere in clause 5.4J is there any specific mention of lawyers, proceedings or legal costs. The scope of J1 is concerned with management. In J2 it is with maintenance, safety and administration. On the respondent's argument, a tenant paying his rent and service charge regularly would be liable via the service charge to subsidise the landlord's legal costs of suing his co-tenants if they were all defendants. For my part, I should require to see a clause in clear and ambiguous terms before being persuaded that that result was intended by the parties. Accordingly, I agree with my lord that the terms of paragraph J of clause 5.4 do not extend to cover legal costs in the service charge. So it just needs to be read in context. It's those specific legal costs that aren't recoverable. So it's the costs of suing defaulting tenants. And the reasoning there is that the language, or to put it in the Arnold and Britton world, those costs of So somebody who is lease compliant, having to contribute through the service charge for the costs incurred in having to chase a defaulting tenant, aren't costs that are concerned with the proper maintenance, safety and administration of the building. But for our purposes, going back to what was said in Kent Square, or what the Upper Tribunal said about Kent Square, it provides no analogue to the present case, because of the materially different focus of the clause, which is their concern with management. And secondly, it doesn't provide an analogue because the nature of the costs, the type of costs that were being recovered in Kent Square and Borace were materially different to the type of costs or the character of costs that are being recovered here. We're not concerned with recovering costs from defaulting tenants. We're concerned with action on advice in the interest of the amenity and safety of the building. Unless I can assist anybody any further.
No, thank you very much. Yes, Mr. Moffat.
I'm here with Miss Green of Council, and if I can just start by saying I'm extremely grateful to Miss Green for her input in this matter. I understand it's her first appearance before this court, and I'm sure that she'll be entertaining your lordships in future directly. If I can, before wading into the substance of the respondents' arguments, just refer to two specific points, and I appreciate that they are, it's contentious as to whether they're relevant to the appeal. Certainly the appellants say that they're not. To some extent, one of the elephants in the courtroom is the sheer quantum of costs involved that are sought to be recovered through the service charge provisions. By the beginning of 2021, some £2,763,000 odd had been invoiced to lessees within the block in connection with the disputed costs. Currently, net of sums that have been received from Ms Hicks in costs, it appears that the net figure is in the region of 2.4 million. So
your first figure was
273,521.
Okay, so that's been reduced to an extent for cost recovery.
And of course, that encompasses all of the stages of the litigation and the planning disputes. It's also one of the salient points here that one has to bear in mind that it's not only the sheer quantum of costs, but also the disproportionality between that and the conventional routine running costs of this block. And it was recorded by the FTT, and there's a reference in my skeleton argument to the relevant paragraph, that the appellants incurred legal and professional fees in 1 year of £1.292 million at a time when the routine costs of running the block and the insurance and so on amounted to some £30,645. All these figures are in my skeleton argument. These were described as eye-watering by Judge Cooke and as vast by the first tier tribunal, and there can really be no dispute about that. The second feature is that these are, certainly in the respondent submissions, unprecedented in nature. I'm going to come back to that during the course of our submissions and how that is relevant. We say there's no evidence certainly the evidence of tribunal decisions which have been looked at by counsel, or indeed anything in the professional guidance to suggest that this is the stuff of service charge, residential service charges, the sort of costs that are recoverable by way of service charge. So I'll come back to how we put that and the relevance of that. But those are two matters which I would invite you to keep in mind when considering the substance of this appeal. When it comes to the permission to appeal, the learned Judge Cooke considered the matter of the reason for a second appeal, the matter of public importance, was the significance of what she described as standard words and the recoverability of litigation costs under standard terms, as she put it, of residential leases. And so I'm going to start by dealing with, in fact, it's the second point made by my learned friend, but never in his skeleton argument. Nevertheless, in my submission, a crucial issue here, really the main issue here, which is the purpose of general words in service charge provisions, the significance of the words used by Lord Newburger in Arnold and Britain and its application in subsequent cases. And to follow on from that, how that should all be applied to this particular appeal and these particular covenants. So if I can start with that point, and I deal in substance with these issues in my skeleton argument at paragraphs 20 onwards. And the starting point is that what we say is that there must be a limit to general words and indeed sweeper clauses. I'm sure you're familiar with that phrase, sweeper clauses, used in commercial contracts as well as leases. But whether it's general words or sweeper clauses, there must be some limitation. And an example of that, it was given in a case called Liverpool Keys. And Liverpool Keys is in the authority bundle at tab 8. And if you turn to page 92, and this was, albeit a decision of the Upper Tribunal, it really explains the basic point that even general words must have a limitation. In this particular case, there was a provision which covered all other expenses incurred by the management company in and about the maintenance and proper convenience.
If you're getting into the details of the clause, I have the same question for you as I put to Mr. Fieldsend about asset hold, which is how does it help us? Because it's not binding on us and we are bound by the Supreme Court.
Yes, but the basic proposition here is that one cannot have a limit, even general words must have some limitation to them, otherwise they become so imprecise that they can have no real meaning. And that was the observation that was made in Liverpool Keys. Of course,
all right, well,
one questions then where that limit,
yes,
where that limit lies.
Okay, so where was that observation?
That was at paragraph 26.
Thank you.
Paragraph 19 is expressed so widely that I find it hard to see what it might cover. The respondents advance a number of propositions. In the first of these is that it's reasonable to expect that if the parties to a lease intended for there to be an obligation for the lessee to contribute to a certain sum, that they will clearly express that. And I've cited as an expression of that the Chancellor's statement in Phillips and Francis, which is another of these residential management cases. And that's at tab 10, page 133. And it's a helpful summary of what the lessor and the lessee position of them during the this what's sometimes been described as the higgling, the point at which they are negotiating the terms of the new lease. And if one turns to page 133 in the Bible, one can see what is stated there. Phillips and Francis, this is paragraph 74. On the other hand, the reported cases are generally consistent with a broad principle that it's reasonable to expect the parties to a lease intend that the lessor should be entitled to receive payment from the tenant. In addition to the rent, that obligation and its extent would be clearly spelled out. See, for example, Georgia and Charlegrove Securities. It is expected that the tenant will wish to be fully aware of such additional obligation on which his or her continuing a right to possess the land and to occupy it may depend. It is to be expected that the lessor will wish to make such a continuing additional obligation clear because it arises under a lease which will subsist throughout successive ownerships of the reversion and the tenancy, and because the lessor will not wish to be out of pocket in respect of services provided for the benefit of the tenant. In the present case, for example, the lease is for a term of 999 years. In a case such as the present, where the service charge is reserved as rent, non-payment gives rise to a particular range of remedies in addition to ordinary action for payment of arrears, and so the precise extent of the tenant's obligation has a particular significance for both the lessor and the tenant.
Well, one can see the sense of what is said in that passage, but the consequence of that good sense is that parties ought to be specifying their obligations with precision in their leases, and yet one sees time and again the use of vague language.
Yes.
So what does one do?
Well, what that tells us is that that if the parties intend for there to be a recovery of a charge, of a cost, that they will clearly spell that out. And if it's not clearly spelled out, it is not recoverable. That is the commercial bargain. And in many cases, landlords take that decision that certain costs in relation to the building will not be recoverable from the lessees by way of service charge. And that is the bargain that is entered into.
So can I just turn that proposition around to see if I've understood what you're saying correctly? So what you're saying there is no presumption that a landlord will wish to recover all costs. It's a commercial bargain.
It's a commercial bargain.
Yeah.
And many landlords, this is particularly the case where one has mixed units, where some units are let on short leases, short tenancies, or business tenancies, and some are let on long residential leases. There's no presumption there should be 100% recovery for all costs in connection with a building, and that is particularly the case where it affects the landlord's investment value for the building as opposed to something which has a direct benefit for the lessee. But that's the bargain that is entered into. What we say is that as a general principle of interpretation, the parties intended that payment obligations such as a service charge should cover a particular type of expenditure, they would wish to make that clear. And that is what was said by Lord Neuberger in Arnold and Britain, and adopted by this court in Ken Square. The passages my friend has already referred to. Now, in terms of Arnold and Britain, perhaps I can a little bit of context is necessary to understand what this reference to general words was. I should say my friend and I have walk-on parts in various cases that are being cited to you. I had a walk-on part in Arnold and Britain, and the argument for my sins, the argument based on McHale was one of mine at first instance and first appeal. But it's important to understand what was being said. It's important to understand what happened in Arnold and Britain. In a sense, Arnold and Britain wasn't a service charge case. It involved some chalets in the Gower Peninsula, and they had unusual service charge provisions. These were modestly valued properties, but they had some unusual service charge provisions. Instead of conventional variable service charge, they had fixed service charges, which were varied at a certain point to increase at a compound rate every year or every 3 years, depending on the chalet involved. And that resulted in a figure, and different figures have been given, but either side of £1 million in service charges being payable by the term date of the lease in the mid to latter part of this century. So the argument was that this was commercially unrealistic because nobody would intend for the service charges to increase to such a level in that way. And it was therefore, that's why it focused on that element of the familiar tests for interpretation of contracts, that it was commercially unrealistic for the parties to have intended that, and therefore it had to be given a different meaning, which was that the leases, that the compound increase had to be subject to a cap of reasonableness. Now, when it, as part of that argument, the McHale argument was prayed in aid, in effect, in support of a contra proferentum type argument. In other words, that stepped service charge or variable, that fixed increase service charge or step service charge should be construed against the lessor because of McHale, and that there was a general principle that service charge provisions were construed against the in favour of the lessee and against the lessor, and that is an argument which was rejected in the Court of Appeal and in the Supreme Court. And that is why we have that statement there, I would submit, as to that service charges are not construed, service charge provisions are not construed restrictively. That is the seventh principle applicable to service charge covenants that was identified by Lord Neuberger. But he went on to say, as been, as you're familiar with, that when it comes to service charge provisions, nevertheless, the general words should not include anything that's not clearly belong there. And that argument in the application of those words to that statement in respect of general words was applied in the Ken Square case in this court. There is no real tension if one considers that one part of Lord Newberg's statement is really to do with a contra proferentum type argument, and the other is to do with the general provisions in service charge clauses. There is another aspect to this, and that is that where one is talking about onerous and unusual payment obligations, there is a familiar principle that particularly clear and unambiguous terms are required. And I've cited a statement from Gayfords and O'Sullivan to that effect. Again, it's an Upper Tribunal case, not binding on yourself. And I'm going to come back to the onerous and unusual payment obligation in a moment. Another principle that we say, and one can see this as applied by the judge in this particular case, and also in a number of cases, some of which have been referred to and some of which I've referred to in my skeleton argument. It's an important point as to the focus of the services provided by the covenant. It's not just a question of the literal words, but it's also the general focus of provision. And if the focus is on management, then it's difficult to extend them to other costs, for example. And those, in my submission, are some of the principles that one needs to look at before turning to the arguments that are raised by the appellant. The way it's actually put in the skeleton argument is by reference to two decisions in a case called Esragi and one in asset hold. The asset hold decision, and obviously we say it's not altogether easy to distill any points of principle from asset hold. The reality is, and one can't get away from it, the main reason that asset hold featured large in the case in the lower courts in this the tribunals below in this case is it's the closest one on the facts to an example of something going on neighbouring property, which has been held to be recoverable under the terms of a service charge provision. Other than that, it's difficult to see why it featured so large in this case. But one of the interesting points is that the Deputy President did actually, at paragraph 59, have something to say about general provisions. What he said was a general provision.
Can you remind me
Which is page 152 of the authorities Bible.
Thank you. Yes.
And a general provision such as paragraph 6 is included in the lease precisely because the parties appreciate that they cannot anticipate all eventualities. The parties must be taken to expect that in an agreement intended to last for 125 years, circumstances may arise which they do not specifically contemplate at the time of contracting. And those are important words. And in which expenditure by the landlord may be necessary or desirable in their mutual interests. The object of a provision such as clause 1.6 is to allow for the recovery of such expenditure through the service charge, so long as it is for the proper maintenance, safety, amenity and administration of the building.
Yes. So Mr. Fields then says that reasoning supports his case.
Well, in my submission, it doesn't, because of those words specifically contemplate at the time of contracting. What's being talked about here is, in a sense, this concept of what is the purpose of the general words. The general words are there to deal with eventualities which arise subsequent to the date of the lease, which were not contemplated at the date of the lease. If they were contemplated at the date of the lease, the parties will have been expected to say, well, hold on, fire extinguishers, let's provide for fire extinguishers. There's fire extinguishers in the common parts. Well, what about aerials? We'll make some provision for aerials, or in this particular case, in recital 6, or definition 6, one of the sub-paragraphs talks about refuse collection, costs of refuse collection. They will have provided for all of that. Whereas there are circumstances, and I can see it, I've given the example in my skeleton argument, that back in 1989, internet connectivity would not have been contemplated by the parties, probably not contemplated by the parties, Wi-Fi provision or whatever. That is something which was not in the contemplation of the parties at the date of the lease, and which is provided for in terms of general words. But if there is something that is in the contemplation of the parties at the date of the lease, they are expected to provide for it.
But this argument is a little odd, isn't it? Because one might say, if it's not contemplated by the parties, then they can't have intended to cover it. So I think what you're talking about is it's the question of the level of generality. So taking your example of internet connectivity, they didn't anticipate Wi-Fi because nobody knew about Wi-Fi. But what the parties must have contemplated is the possibility of future technological development, because technological development was something that was already well known in 1989. And so the question, therefore, is, as I say, one of the degree of generality of their contemplation.
Yes, well, no, actually I would say no. Actually, I would disagree with that.
Right. Why is that wrong?
What I would say is that the general words are general words. They are subject to limitations. So, for example, the general words here are subject to all kinds of limitations as to what they must be, what costs must be incurred in relation to maintenance, administration, so on and so forth. But the general words are not there to deal with lazy drafting. They're not there to simply say, well, sorry, we forgot quite a lot of costs. And there's no point in us actually bothering about specifying some of these other things that we know about. Obviously, in our particular case, we say the difficulties over contentious nature of the rights in respect of the neighbouring property. That when it comes to the general words, that's what they're there for. You cannot, in my submission, when you come to looking at the what is known at the time of the lease, what you have to do is to have regard to the fact that certain costs are specified which were contemplated at the date of the lease, and others were not specified.
Can I just ask one more question on this topic and then I'll desist? You referred us to what the Deputy President said in Asset Holding, as I commented earlier, that something Mr. Fieldsen himself relies upon. But the sentence, or one of the sentences that you read, talks about circumstances may arise which they do not specifically contemplate at the time of contracting. And what I was trying to do in my earlier question was to focus upon the word specifically. Because if it's not contemplated at all, then the parties can't have agreed to it. And at the end of the day, this is what we are concerned with. We are concerned with what the parties have agreed.
Yes.
We're not engaged in an exercise of imposing or something on them which they haven't agreed. So what the Deputy President there is recognising the reality of life, namely things happen which you may contemplate as a general level, but you don't contemplate the specifics. And that's what I meant by the level of generality. So if I rephrase it in that way, would you agree?
Well, I wouldn't, because I think in my submission, giving the example of the technical development, one might well therefore have expected the parties then to have said another, using the general words and referring to other technological equipment of a like nature to the aerials and the and so on and so forth, to explain what the general words were. But that's not obviously what is used here. In my submission,
Anyway, enjoy your lunch, Faith.
Back to office out, I think, aren't you?
I'm going to the loo now. I'm desperately going to the loo. Right. See you later. See you later.
I just dive back in to grab my stuff.
Yeah, because Faith's got to lock up, you see.
So you're going to the moon, are you?
She's the boss. She's the boss.
Yes, it's a pleasure I have.
Yeah, it's nice.
She's, you know, she was saying the tax
She's the
law.
boss.
She's the boss, but she was saying the tax law ones are the most boring. I was saying like, oh,
Yeah, because
how
it's
hard.
very, very technical.
Yeah. No, this obviously is technical, but it's understandable
Yeah.
if you've got some knowledge. Right? Whereas the technical, the tax stuff, you either know before or you don't.
Yeah,
It's simple as that.
and they always like refer back to the white law book. Because I haven't read it yet, I don't really know much about it. So yeah.
I've been in a worse position than you, probably,
See you later. Take care.
despite the fact that I've run companies. But anyway.
See you.
See you. Thank you, man. Appreciate it.
What do we get out?
You're already locked out. Just push it.